Welcome to Panel 3 of Justice Thomas's 30-year legacy on the court, Originalism, Constitutional Interpretation, and Starry Decisis. Please welcome our host, John Malcolm, Heritage's Vice President of the Institute for Constitutional Government and Director of the Meese Center for Legal and Judicial Studies.
Well, welcome back, especially to our virtual attendees who had a little bit of a break there. We're going to get right to our next panel. We are fortunate to have as a moderator Judge Greg Katsas of the DC Circuit. Before Judge Katsas was on the bench and when he was in private practice, he argued over 75 appeals, including 3 cases at the High Court. He also served as the head of the Civil Division and the acting Associate Attorney General at the Justice Department during the Bush administration, and of course as a Deputy White House Counsel during the Trump administration. He clerked for Judge Edward Becker on the Third Circuit, and then he clerked for Justice Clarence Thomas. Judge Katsas, it's over to you.
Sorry, I'm a little bit out of breath and disheveled here. For those of you who know the DC Circuit, it might not shock you to know that my 1.5 hours of argument this morning went for over 3.5. But I made it. I'm thrilled to be here moderating this CT Clerk panel on Originalism, Constitutional Interpretation, and Starry Decisis. Given the panel's composition, I'm just going to introduce people in the order in which they clerked for the justice.
Very diplomatic.
So leading off is Chris Landau. He is the St. Andrew of Thomas clerks, the first called. He was the justice's first clerk at the DC Circuit in April of 1990, and then the justice's first clerk at the Supreme Court 30 years ago this month in October 1991, and was absolutely essential in helping the justice get both chambers set up and get everything off to a great start. In between his CT clerkships, Chris also clerked for a fellow named Antonin Scalia. You might have heard of him. And after his clerkships, he became one of the country's premier appellate and Supreme Court litigators at Kirkland and Ellis and then Quinn Emanuel. And from 2019 to 2021, he was our ambassador to Mexico. Greg Maggs was a co-clerk with Chris and me in OT 91, joined us after clerking for Judge Joe Sneed on the Ninth Circuit and Justice Kennedy at the Supreme Court. After clerking, he became distinguished law professor at GW, and in that capacity taught many courses with the justice. He served for almost 3 decades in the Army Reserves, and he is now a judge on the Court of Appeals for the Armed Forces. Erik Jaffe clerked for Justice Thomas in OT 1996, after a clerkship with my colleague Doug Ginsburg and a stint at Williams and Connolly. He is a founding partner in the firm Schaerr Jaffe, and like Chris, has some 3 decades of experience as an appellate and Supreme Court litigator. Last but not least, Jim Ho clerked for the justice in OT 2005. After a clerkship with Jerry Smith on the Fifth Circuit, a stint at DOJ early in the Bush 43 administration, and service as general counsel on Senate Judiciary Committee subcommittees. After clerking, he became a partner at Gibson Dunn in Dallas. He also served as Solicitor General of Texas, and he is now on the Court of Appeals for the Fifth Circuit. We're a little bit front-loaded on early clerks for the boss, but we will try to cover all 30 years as best as we can. This panel is about methodology, how one should do constitutional interpretation, among other things. If you're thinking about the best way to do that, the 2 main competing approaches. One, of course, is originalism. Randy Barnett gives a pretty good working definition that originalism is school of thought under which the meaning of the Constitution is fixed when was fixed when the Constitution was enacted or ratified. That's a proposition about how language works, and then that fixed meaning should constrain what interpreters do in deciding cases in the present day, which is, of course, a normative claim about how we all as judges should decide cases. Of course, Justice Thomas is the world's leading practitioner of originalism. He has said things like this dozens, if not hundreds of times. I'll just take one example just to put something concrete on the table. In the McDonald case, in the context of addressing the 14th Amendment, he said that the Constitution should be interpreted, now his words, consistent with the public understanding at the time of ratification. Our other topic on this panel is stare decisis, which is the question how precedent impacts or constrains constitutional interpretation. It's a critical question for modern originalists like Justice Thomas because, of course, the Supreme Court has been decidedly unoriginalist since at least the 1930s. If you survey the constitutional law of today, maybe you'll find significant strands of originalism in the Second Amendment and the Confrontation Clause, but for the most part, most of the clauses are encrusted with decades of living constitutionalist precedents. So if you think originalism is right as an original matter, but you also think that precedent constrains judges, there's really not a whole lot you might be able to do to operationalize the theory. So that's the challenge for stare decisis. The canonical formulation of stare decisis is that it's a doctrine of prudence, that you need specific justifications to overrule cases above and beyond simply the cases being wrongly decided, and that inquiry is a multi-factor balancing test encompassing things like the quality of the precedent, the age of the precedent, intervening developments, reliance interests, etc. Justice Thomas, a couple of years ago in a case called Gamble, set forth a somewhat different, less expansive view of stare decisis. He said, and again, I'm just going to quote him once. He said, "If the court encounters a decision that's demonstrably erroneous, which is one that's doesn't rest on a permissible interpretation of text, the court should correct the error regardless of whether other factors support overruling." This is interesting for a couple of reasons. Obviously, he's giving less weight to precedent than the traditional inquiry. He is giving some. He requires demonstrable error as opposed to error. The other interesting thing is he's constitutionalizing aspects of the doctrine, limitations on the doctrine. He says that the Constitution specifies the binding law, which is constitutional law, not what judges say about it. And in that sense, he might be moving things away from a prudential inquiry and maybe moving things a little bit in the opposite of a recent suggestion from Justice Kavanaugh that the Constitution constitutionalizes not limits on the doctrine, but the basic doctrine as an aspect of how judges decide cases under Article 3. All right, I've said enough. Our panelists have chosen not to do opening statements, so we are going to jump right in, and I will start posing some questions, but I hope the discussion just takes off and I can sit back and catch my breath here. So the first one is, I gave you a very simple definition of originalism, but there are a bunch of different variations on what one might look for. Original intent, original meaning. This is something Greg Maggs has written and thought a lot about. So Greg, why don't you give us a primer on exactly what it is that the boss is looking for?
Well, thank you, Greg. And let me just start by saying thank you to the Heritage Foundation and the Gray Center for putting this together and inviting me. It's a great honor. In terms of originalism, there's been a long-standing disagreement once you get past the idea of whether we're going to follow the original meaning or not as to how to define the original meaning. For example, is it what the framers originally intended, the framers in Philadelphia in 1787? Is it what the ratifiers of the Constitution at the state constitutional conventions thought it meant? Or is it what the public would have thought, what the original objective meaning is? And it's somewhat of a theoretical debate because often the meanings aren't different, but the sources that you look at in trying to determine these meanings may differ. So for example, if you're trying to figure out what the framers of the Constitution actually intended it to mean, you might look at the records of the Constitutional Convention. If you're looking at what the ratifiers thought it meant, you might look at the debates in the state ratifying conventions, and you might look at, say, the Federalist Papers and the Anti-Federalist Papers and other arguments at the time about whether we should ratify it or not. Where by contrast, if you're looking at the original public meaning or original objective meaning, as it's sometimes called, you might look at sources such as legal treatises, dictionaries. Currently, the trend is to look at corpus linguistics, just how were words used at that time. And for many years, Justice Thomas did not specifically articulate what type of original meaning he thought was controlling. But we did see, if you just saw the movie, the clips from the movie over the lunch hour, in the McDonald case, he specifically said it's the original public meaning, which would suggest that sources such as dictionaries from the founding era and other sort of objective public documents, as opposed to what the framers subjectively thought or the ratifiers thought, would be the most relevant. And you can see that in many of his cases. Justice Thomas probably cites dictionaries more than any other justice. In the United States v. Lopez, he cites dictionaries for the meaning of commerce. In Kelo v. New London, he cites dictionaries for the use of, for the meaning of the word use. In Bays v. Reese, he looks at dictionaries for the use of, for the meaning of the word cruel. In Carpenter v. United States, he looks at dictionaries for the use of the meaning of the word search. And I think this is pretty consistent. That said, he also does look at other sources, and particularly in his older opinions, he seems to focus on many other kinds of sources. So during the morning program, there was a lot of discussion of the term limits v. Thornton case, and that relies very heavily, say, on the Federalist Papers and the Anti-Federalist responses to them, as opposed to dictionaries. I think it's also true that this method of using dictionaries works best where you have a lot of specific words, say like Article 1, Section 8, you're trying to figure out what the meanings are, or the Bill of Rights. In Article 2, where we're talking about the scope of the president's powers, it's a much more structural kind of question, and it doesn't usually help to look up what it means to be the chief executive or the commander-in-chief so much as it is to look at the structure. So that's what I would say is the answer.
One idea we were kicking around a little bit as the panelists were discussing topics is the possibility that the nature of the inquiry might vary depending on the underlying clause and whether it's open-ended or closed-ended. Erik, you had brought that up, so is that something you want to elaborate on?
Absolutely. I mean, I think it's sort of interesting that, you know, a lot of people, I think, falsely equate original public meaning with how would the people of the time have applied the particular constitutional provision in that era, as opposed to how they would have understood the language. And that comes into focus on certain language that is not fixed in its nature, unusual, cruel and unusual punishment. They didn't say unusual today, they just said unusual, and one might reasonably understand that to be open-ended and forward-looking, that things could become unusual or not, as the case may be. There are other instances, due process. I mean, due process may have had a content at the time, but the concept of due process might have been a broader concept of what is just and right, giving some open-endedness to certain clauses, even privileges and immunities. Even the Ninth Amendment, for example, suggests that there's a certain open-endedness, and that while there's a fixed meaning to language, the language itself may not fixate on a result. It may fixate on a process, it may fixate on an overall conception. Things like the judicial power, similarly, could be sort of something that gives open-endedness. And so I find it interesting in terms of the debates we have even within the originalist camps, and how Justice Thomas deals with those. One thing that always I found interesting is that he often would look to public documents and newspapers and things like that for meeting, and you see that's reflected now in corpus linguistics, which you're looking to much more public and common materials to see what the public actually would have thought, particularly the public that might not have had a law library with a bunch of dictionaries in it, right? So you're looking at things the public really read rather than the things that they theoretically could have read. And I think that's a useful thing. You know, much as we of the originalist camp or the textualist camp tend to deride legislative history, that's different than saying you can use historical documents like that to show meaning, not to show intent, which is the distinction that Judge Maggs made, but to show meaning. And so I think Justice Thomas does this. The example that always came to mind for me was in the Camps Newfoundland case, which was done in my term, OT 96. He wrote a dissent talking about the meaning of the Import-Export Clause. And much of the sources cited there were newspaper articles about what were imports and exports, even though perhaps more modernly, and maybe even some definitions might have had a narrow or different definition of imports. The common understanding meant imports and exports between states, not necessarily only between countries. So all of those things I find interesting. I find the justice, his dealing with this over time. I think it's evolving. He takes things, he plays with things, he looks at things. I think it's all an inquiry into what is ultimately correctly, what was the meaning as understood at the time, how would people have understood the words, not what result would they have come to.
Erik, if the meaning is fixed but open-ended and forward-looking, and you sharply distinguish meaning from, let's just say, expected application, to use a jargon term in this area, how do you stop the slippery slope down to, you know, the equivalent of when you're deciding an Eighth Amendment case, you apply evolving standards of decency? I mean, whether you describe it as the standard is evolving or the standard is forward-looking, so judges look to the present, seems like those are pretty similar.
Well, one would be objective. If you think unusual is a factual question, is it or is it not unusual? You would have some measure of usualness. Is it 1 out of 1,000? That would be unusual. If it's 1 out of 1,000,000, that would be unusual. Is it 50-50? That's not terribly unusual. So yes, there would be evolving standards of decency, but there wouldn't be the evolving standards of decency in the judge's mind. It would be some objective external measure if you thought that's what unusual meant. So the slippery slope wouldn't exist vis-a-vis judges running rampant, though of course it would allow for some evolution in concepts like unusual, like what is and isn't unusual, and potentially what is and isn't cruel.
So your point is it wouldn't be what was unusual in 1789 or 1790?
Not necessarily. I'm merely positing this as a plausible reading of the word unusual, even from that time period's understanding.
All right, but suppose unusual is, you know, something rejected in X number of states, and we come to the woke present and X number of states have rejected capital punishment. Does that make capital punishment unconstitutional, notwithstanding the overwhelming structural and historical arguments that, of course, it's constitutional?
If you think that it is not a fixed standard, that the meaning at the time was not intended and understood to be a fixed standard, then yes, that's exactly what it would mean. It would mean that eventually, if all but one state decided capital punishment was wrong and banned it, it would become unusual. It might not be cruel, by the way. It would just be unusual at that moment. One could debate about the cruelty, and I think you're probably right that it would be hard to imagine it was cruel given the
If
express
cruelty works the
authorization.
same way, maybe you could have the same ratchet.
If it does, but again, that's just the question that has to be asked, and we shouldn't shy away from the possibility that the answer might be yes. We should just ask the question, look at the history, look at the language, and come to the answer. I'm merely saying that just because we have fixed notions of language doesn't mean that all language has fixed notions of outcome.
Okay. Chris or Jim, anything you want to?
I think there's some, I mean, I think some language, some parts of the Constitution are very, very specific. Like the president has to be 35 years old. That's not going to evolve to say, well, standard of living was different then, and so now we're going to say the president, has to be 45 years old. I mean, I think that's something that everybody would agree. The language answers that. I do think that there are some parts of the Constitution that are more open-ended, like a search must be reasonable, and by definition, you can look at the definitions, but that does seem like it's a more open-ended provision. And the question then is, what guideposts do you use for reasonableness? I mean, I guess one legitimate guidepost would be what was reasonable at the original time. Another would be, what is reasonable in our day. And then the question is, how do you measure that by some objective indicium? I think at the end of the day, the question is basically, how do you do your job as a justice? And I think Justice Thomas has always had the view that he is not there to impose his own views. And so I think whether it's originalism or textualism, he is always looking for something that says, I don't want to impose my own views. I want somebody to give me something that I can look to and say objectively, I have legitimacy because I have an objective standard of how I do my job. And again, I think originalism is a tool that gives legitimacy to his work, or textualism, or again, I think sometimes the boundaries of these doctrines become very difficult. But I think at base, the question is, what is a justice's job, or what is a judge's job under our democratic system? And I think Justice Thomas's great contribution is that he, probably more than anybody, has made it clear that he doesn't want to be a philosopher king. He wants people to give him objective answers for how he can do his job, objectively and not based on his own personal preferences. And so I think, these are all useful means to an end, and they're good conversations to have. I think in most cases, whether it's original public meaning or the framer's intent or what the language meant, I mean, they wind up coming out the same way. But again, I think Greg Maggs had a very interesting point that, some of the provisions of the Constitution are very are not written in the sense that the executive power, what is in the executive power? You cannot answer that question within the four corners of the document. You do have to look at some external source. And so the question is, what is that external source? I mean, does the power to appoint encompass the power to remove? The Constitution doesn't speak to removal. So how do you address that question? And, I think for Justice Thomas, he is always looking for ways to prevent judges from running amok with their powers. I mean, Lord knows we've seen this, go on for long enough. And Greg, I think you really hit the biggest question of all, which is how to be a purist in a fallen world. I mean, how do you, in a world where, the First Amendment says Congress shall make no law, but all of a sudden you have a First Amendment case based on what the local school board in, Pittsburgh, did. How do you even start to analyze that case if you say you're a textualist and you are, and you want to do it right, in a sense, if you don't at least follow incorporation, you're just going to be marginalized in all these cases, and the court goes on without you. And I think, to me, that was always the biggest struggle to, how you draw lines in the area to say, well, I'll accept this precedent, but not that precedent. And again, those are ones where I think Justice Thomas is trying to do his job as he sees best, but it is very difficult to do. I mean, again, so I think, to me, that's the hardest of all these questions to answer in terms of methodology. It is a stare decisis question ultimately, and I think that's something that he struggles with, frankly. I'm not sure there is a neat and easy resolution to that struggle.
So one way, I think it's been a wonderful dialogue, and I will do my level best to add something minimally valuable. One way I would sort of summarize and simplify what Chris has said, and I think I agree with every word, is that essentially Justice Thomas, when he signed up to be a judge, when he swore an oath to be a judge, he wants to, in fact, be a judge. And that means not simply figuring out what he personally would want to do as a voter, or, frankly, what he thinks the public pressure or pressure from certain parties or for certain constituents groups, what they would want to impose. He simply wants to be a judge, and that means figuring out what law he's supposed to apply to a particular dispute and apply that. We've had, obviously, a great exchange about the sort of various different strands of originalism between Erik and Greg. Let me maybe take a slightly different take and say, To the extent that, what makes Justice Thomas stick out as a unique originalist is that he's a fearless originalist. And specifically, to paraphrase what he said during his confirmation hearing, he is a judge and a man who deigns to think for himself. And so one way in which that manifests itself is that he looks for original meaning everywhere, including, most interestingly to me, where everybody else has essentially stopped looking. And there are examples where essentially everybody is sort of just, for whatever reason, focused on other areas. He's going to actually get back to the original meaning when everybody else has stopped asking. So, I'll just use 3 examples. Holder v. Hall, where he basically went back to trying to figure out, where is this vote dilution claim theory coming from? Everybody just assumes it exists. He wants to ask, what is the original meaning of the Voting Rights Act? The Establishment Clause in Elk Grove Unified School District versus Newdown, and in other cases, he asks, does the Establishment Clause, is it even appropriate to be having those discussions in a state or local government context through the doctrine of incorporation? I think there was some allusion earlier today about his wanting to revisit New York Times versus Sullivan, the First Amendment, and how it applies to libel law. He said that in McKee versus Cosby, and in, I believe, another later case as well. And so he's willing to ask the original meaning question when everybody else has stopped doing it. And I think your point about Starry Decisis is extremely well taken. The notion that you're going to be an originalist in these cases, but not over here, that really isn't originalism at all. You're just deciding, well, originalism works here because it gets you to the result that you want, so you apply it. Same thing with Starry Decisis. Whatever theory of Starry Decisis one wants to have, and we can have a legitimate discussion about that, the one standard it has to pass is it has to be a principled theory of Starry Decisis. It can't be, oh, I like this precedent, so I'm going to apply it. I don't like this precedent, so I'm going to be less oriented. That's the one thing that no principled judge should possibly accept. And certainly that's, I think, how Justice Thomas has essentially encapsulated his whole theory of judging.
I think you're right. I think one of the reasons that we're here today celebrating Justice Thomas is just as you said, Jim, that he will go back to basics in a case, and there's so many areas. It's basically every case now. The Constitution or the original statute is here, and then there's all these barnacles that have grown up over the year. And typically, a case comes and there's a circuit split on, interpretation of this barnacle, right? And so, in a sense, you can't really answer that question in a very meaningful way unless you kind of go back to the original thing. And sometimes there's some real problems in the original thing. And I think he's somebody who's willing to say, hey, time out, everybody. Even if it's not presented by the parties sometime, because the parties are taking the law as it is too. And, I think he recognizes that the Supreme Court has an important function of calling out issues for reexamination. And, because the lower courts can't really do that, right? I mean, I guess, you could try, but it's certainly, the Supreme Court, it's kind of appropriate for people to start asking, how did we get to this barnacle? Or at some point, you get past the logical extreme of something. And he's always willing to, in a sense, be very candid. And I think that's a very valuable tool. I think so many judges feel like they have to make excuses and they won't overrule something because it looks bad for the judiciary to overrule in their mind, and it says they made a mistake. I think he'd rather say, look, let's just be over with it. Let's admit that was a mistake. Let's be candid about this. Let's be truth tellers. Let's not try to, we don't have to become complicit and cover up that we made a wrong turn somewhere. And I think that's the kind of person he is, and there's a lot of value in that.
Can I pick? Okay. I was just going to pick up on Chris's barnacle metaphor. Justice Thomas had a very similar view, but a slightly different metaphor. He gave a speech when he won the Learned Hand Award that the New York State Bar Association gave, and he analogized precedent to a train, where he said every time we have a new case, we're adding another car to the end of the train, and we just keep adding another car to the end of the train, and pretty soon we forget who's driving this train, where did it come from, where's it going. We just keep putting a new car on the back of that train, and one of the things he likes to do is find out where things come from. And Erik pointed out earlier that we've got the evolving standards of decency test for cruel and unusual punishment, and in a course that Justice Thomas teaches, a student wrote a paper on where that came from, And it didn't have anything to do with the death penalty. It had to do with the collateral consequence of a court-martial. In North Africa, in World War II, a soldier got fed up, walked off post, got cold and hungry, turned around, was arrested, was tried for desertion, 2 hours of desertion, was punished, finished the war, went home. Many years later, he applied for a passport to take a business trip to Canada, only to discover he was no longer a U.S. citizen because there was a statute that said if you desert in the face of the enemy during wartime, you lose your citizenship. And went up to the Supreme Court, and that's where it wasn't even a habeas corpus case, it was a case to get a passport. That's where they came up with the evolving standards of decency test, which ultimately ended up with the Supreme Court, at least for a while, holding that the death penalty was unconstitutional. And where is that train going to, and where did it come from?
I want to pick up also on the same thing Chris mentioned about the barnacles or the trains or however you want to call it. It was one of the most foundational experiences I actually had with the justice early on, where, I'm some smart alecky young person who thought I was really good at the law, and I write a bench memo.
Some things haven't changed.
Yeah, well, not at all. I'm not young anymore, though. I'm just not young anymore. The rest of it's still true. I give this wonderful analysis of precedent and this and that, and he just sort of looks at me and said, yeah, but like 50 years ago, we sort of screwed up this one precedent, and all of that doesn't make any sense in light of that. And I'm like, I was floored. I was literally floored at that moment that he had sort of stepped back and away from what we had been taught in law school and told me, you need to look deeper. And it was really, it was both an educational experience in the clerkship and for the rest of my legal career, quite frankly, of not taking things at face value, not accepting the given wisdom, but looking back and seeing if it makes sense. It was glorious.
I have a similar anecdote that actually ties out into the train metaphor that three of us here were Justice Thomas's law clerks his first term on the court. And obviously he was dealing with a lot of these questions that very first term. I mean, it was really the first sitting, I think, where all of a sudden you're faced with these very real questions. And so I remember there was one particular case and we spent a long time among all the clerks and the justice discussing this case. And, he went off to conference. And, we always peppered him with questions as soon as he came back from conference, like how did it go? And, what was the vote on this or that? And, the Supreme Court does it, I think, differently than the D.C. Circuit and that most other courts, that they go in order of seniority. So he was actually the last person to speak up. The Chief Justice starts and it goes by order of seniority. Is it still the way in the D.C. Circuit that it goes?
We do the opposite. Junior judge goes first.
That's what I think. How is it in the Fifth Circuit?
Same.
Okay, but in the Supreme Court, for some reason, it goes senior to junior. And so, imagine 8 people had spoken on this case before it got to brand new Justice Thomas. It was his first sitting, and so he came back to chambers and said, "Okay, that case, it's 9-0 against the position that we discussed." It was like 9-0. He's like, buddy, that train had left the station. And, but then, he slept on it and he came in the next day and says, something? I don't think that was right. I think I swore an oath to uphold the Constitution and do my best to do what's right. And, I'm going to try to write a dissent along the, write my views along the way that we thought. And, and he did that.
I've told this story in public before, but to me, one of the most amazing judicial performances I've ever seen was his performance in that first sitting. So he's just gotten to the Supreme Court. He's 43 years old. He's been through hell. He's trying to get the chambers set up, right? And he went into conference and he was the sole dissenter in 3 cases from the first sitting. And I can say all this in public because it's reflected in Justice Blackmun's papers, which are now public. But one of them came out 8-1. One of them came out 7-2 with Justice Scalia flipping his vote to go with Justice Thomas. And one of them came out 5-4 with Justice Scalia, the Chief, and Justice Kennedy flipping their votes consistent with the Thomas position. And a lot of us ask ourselves questions about, tactics. Is it worth it? Will I burn too much capital? Will it take too much time to fight this fight? Has the train left the station? He didn't ask any of that. He just asked himself, what's the right answer on the law, and went with it. And, maybe he slept overnight on one case, but other than that, he never batted an eyelash over those votes.
Yeah. It's one of the reasons I think has had such an impact. I mean, I remember I've been on panels that kind of discuss, who was the more influential justice, Justice Brennan or Justice Scalia? And Justice Brennan was a master at kind of compromising and getting 5 votes. Justice Scalia and Justice Thomas are at the other extreme, and they're not Justice Thomas is not trying to twist anybody's arm. Nobody bothers to come to Justice Thomas's chambers to try to twist his arm, because people know that he calls them as he sees them. And it is an interesting debate. I don't think there's a right or wrong answer to which is ultimately, in terms of the long-term effect on the law, more effective. I mean, Justice Brennan certainly accomplished a lot by his kind of cajoling and willingness to make deals. But I think maybe the Scalia-Thomas view over the long run, it comes up with a very coherent theory of constitutional interpretation that, my sense is that there's a lot of power in that too. One is more results-based and one is more methodology-based. And ultimately, I mean, the results were very important. They've changed our country in very significant ways. But the methodology matters a lot too.
Greg, one detail that you didn't add was, after all those cases came out, the headlines read, "Justice Thomas just does what Justice Scalia tells him to do."
Yeah, exactly.
Right.
Exactly.
I think on the who's the most important justice, I think Justice Thomas is a lot like Ronald Reagan is to political candidates. Everybody says, if they want to get a certain class of votes, I'm the Ronald Reagan in this campaign. I'm the Ronald Reagan candidate. And I think whether Justice Thomas has, we talked about how many wins they had, and Adam Mortara had the question of how the NFL highlights, and there are individual cases, but I would say the biggest win is when you look at new nominees, they're not compared. Who are they compared to? They're compared to Justice Thomas and Justice Scalia. Is Brett Kavanaugh going to be like Justice Thomas and Justice Scalia? Is Neil Gorsuch going to be like Justice Thomas and Justice Scalia? Is Amy Coney Barrett going to be like them? And I think that is the most significant influence that they've had because of their principal jurisprudence.
Talking about some of these procedural issues on his influence on procedural, I want to go back to the precedent question for a bit, because, as I think several people have mentioned, his limitation on where precedent does and doesn't go in is it demonstrably wrong? But to me, I hear echoes of Chevron in that. I constantly hear echoes of Chevron. Well, what if it's not demonstrably wrong? What if the historical record is ambiguous, or the language is ambiguous, or there's conflicting evidence? What do you do then? And that's sort of the more interesting thing about how do you deal with precedents that you're not just going to put your foot down and say, it's clearly wrong, I can't abide it. But maybe there's a palpable argument one way or the other. And at least in my experience, what he tried to do is steer it back as best he could to something closer to what he thought the right answer was, even if it wasn't the definitive absolute answer. And I think that's an equally good methodology for dealing with those spaces in between, if you will, is get it back to the logic and the sense of the overall structure, even if you can't say for sure it means X.
So I was going to also say on the demonstrably wrong, I mean, the alternative is the Supreme Court's current doctrine, which is a multi-factor test where all the factors have been established by precedent, so we have our test for stare decisis where all the factors are made by precedent.